Hey everyone. I keep moving the camera and they keep moving further and further away. I don't know. Whatever. I hope everyone is having a wonderful Monday. It's Monday, right? Where's my phone? I usually need my phone to tell me what day of the week it is. Let's finish this thing. Like, we're almost done. All we have left is closing arguments, and then we can move on with our lives. No more frats, no more craziness. So let's get it started.
So you don't need me to keep the record open for purposes of getting more from Mr. Maddox.
Close the record for Mr. Maddox.
And for everyone else.
Yes, for
All
everyone
right.
else. We're good.
The record is closed, and I am happy to hear from you all about why I should grant the motion, and from Mr. Costello or Ms. Jackson as to why I should not grant the motion.
And Your Honor, because this is my motion, I reserve the opportunity to open and close.
I will give it to you.
And also, if you don't mind, may I approach to give you copies of case law?
Sure.
Good morning. Good morning. Hey. So she's not in the frame right now, and she'll start that way, but she will get, they will fix the camera.
list of cases for you.
Really? Seriously? It's like a bowling pin split. I finally get them right there, and one
So
goes
we've
each
heard
way.
testimony from multiple people through the course of 2 days. So I'm just going to go through with the argument. Your Honor, as you are aware, OCGA 16-321 allows an individual to use force in defense of self and others. The statute specifically states a person is justified in threatening or using force against another when and to the extent that he or she reasonably believes that such threat or force is necessary to defend him or herself or a third party against such other's imminent use of unlawful force. However, except as provided in Code Section 16-3-23, a person is justified in using force which is intended to or likely to cause death or great bodily harm only if he or she reasonably believes that such force is necessary to prevent death or great bodily injury to himself or herself or a third person to prevent the commission of a forcible felony. It is our argument today that Mr. Thomas acted lawfully and in accordance with OCGA 16-3-21 when he fired one round at Mr. Kendrick Cooper on May 15th, 2021, following the threatening and forceful actions of Mr. Cooper. Hit v. State 293 GA 415 2013, which also cites Fair v. State 284 GA 165 2008, and State v. Yapo, and that's GA, sorry, I don't have the case site, the numbers in front of me, but it's a Georgia Act case, and it's a 2009 case. And it states that Georgia's immunity statute bars criminal proceedings against persons if they present sufficient evidence at a pretrial hearing to persuade the trial court that they were acting in self-defense. HIP further explains that sufficient evidence is evidence showing by a preponderance of the evidence that Mr. Thomas is entitled to immunity. So a showing of 51% is necessary. In this case, evidence came out in a hearing that Mr. Phil Thomas was at a friends and family cookout, one in which he was invited to by his fraternity brother and friend, Christopher Swain, actually his neo, Christopher Swain, and Mr. Kendrick Cooper turned a family-friendly event into a contentious atmosphere. stating that all the new members of Omega Psi Phi needed to get good with him. Or in other words, they needed to commit certain acts to demonstrate their status within the fraternal organization. In an attempt to keep the event family and friendly oriented, Mr. Thomas attempted to explain to Mr. Cooper that this was not the time or the place for that. This was not the time or the place for fraternity matters. We're here having a family and friends barbecue. This is not an Omega event. And once away from the group of individuals who were sitting in this driveway, Mr. Cooper and Mr. Thomas went to the side where Mr. Thomas explained.
So real quick, that just made me think of something. So say you're having a work function and you bring your significant other and you're having like a Christmas party or something. It's still a work function. I mean, you're there because of work. So it kind of feels like they keep saying it's not a fraternity event. Well, you know, your association is because of the fraternity, right? Or am I thinking of that wrong? My brain's fuzzy today. Correct me if I'm.
To him, hey, I'm not 2021. However, you can have a conversation with me. Obviously, this upset Mr. Cooper, and the interaction changed a little bit. The dynamic of the party changed a little bit. And Mr. Cooper, who indicated that he was the live five, became irate and he began to threaten Phil. Now, whether, and I'm just going to be as explicit as everybody else was today and yesterday, whether the words motherfucker was used, whether they weren't used, there were explicits that were yelled and there were threats that were also made. And I'll kill you, or I will kill you, or I could kill you. But during that interaction, it is clear that Mr. Cooper gets upset. And based on what Mr. Thomas testified to, which is very similar to what Mr. Carter testified to, and I'll go through his testimony separately, upset Cooper, then knocks Phil Thomas's drink out of his hand. And as he's doing so, he punches Phil in the face. Phil has to then clean up the mess that has been made by Mr. Cooper. And we get to Mr. Cooper spilling the drink on Mr. Thomas from Mr. Thomas showing deference. Everybody talked about deference while they were on the stand for the most part.
They fixed the camera in just a minute or maybe a few minutes. Those cameras through this whole thing was a mess.
And as an act of, let's just squash this, Mr. Thomas says, hey, what are you drinking? Because I'll get you a cup of whatever it is that you're drinking. And then we get to Mr. Thomas's drink being knocked out of his hand and his face making contact, or Mr. Cooper's fist making contact with Mr. Thomas's face. So Mr. Thomas walks away from the situation. He doesn't further engage Mr. Cooper. He goes to clean himself up. The evening continues. Mr. Thomas is over here minding his business. Coop is over here doing other violent actions that I'll get to in a second. But Mr. Thomas is minding his own business. He's enjoying the rest of the night. Throughout the night, Mr. Cooper and Mr. Thomas get into another altercation. Mr. Thomas has been instructed by other, or encouraged by other fraternity members to go have a conversation with Coop. Coop is younger than you in the fraternity. You're the older person, go be the bigger person, go have a conversation with Coop. Mr. Thomas goes to have a conversation with Coop. That conversation doesn't go so very well either for Mr. Thomas. And that ends another negative altercation. Once that altercation ends, you have according to Mr. Thomas,
have
you
something
have
pretty to look
what
at.
transpires into the incident. And the incident is the shooting that we're here to talk about. Because honestly, Your Honor, the buildup is important to the immunity motion, but the moment in which Mr. Thomas shot is what's most crucial. So Mr. Thomas is outside at his vehicle. He's getting ready to leave. No, he doesn't leave the party earlier because he doesn't have to. He's still enjoying the party just as everybody else is enjoying the party. Mr. Thomas is at his vehicle, minding his business, talking to his friends, getting ready to leave. And when I'm sorry.
When you say, it's okay. When you say his friends, my recollection is that it's just Mr. Swain who's there with him at the time Mr. Cooper comes up. We've heard conflicting evidence about whether there were people trailing Mr. Cooper, trying to get him back into the car he'd come out of. Is there someone we didn't hear from who we should have heard from because he was standing right there with Mr. Thomas and Mr. Swain?
No, Your Honor. My understanding is Mr. Carter was at some point near the vehicle, then he walks away.
Right. Mr. Carter. I forgot. You're right.
Okay.
I don't think I've ever heard a judge interrupt a closing to ask questions about it. That's interesting.
Okay.
So they're having a conversation. Mr. Carter gets his plate that he never gets to take home.
Yeah.
But anyway, Mr. Thomas is minding his own business, and he is at his car, and he's getting his charger. His charger's in his hands, his keys is in his hands, his gun is in his hand. And all of a sudden, take my shoes off.
She's taking her
All of a
shoes off.
sudden,
Wow.
there is Cooper, who's been irate
We
on
can't
more
see
than
it.
one occasion, running with his head behind his back, just like this, pointing and threatening Mr. Thomas. And as he gets to Mr. Thomas, that is when Mr. Thomas backs back a little bit and fires one round. And that one round hits Mr. Cooper in the stomach, and also somehow ricochets, we don't know that because we didn't have a medical expert testify, but somehow finds a way and hits Mr. Swain. Mr. Swain, I'll get more in detail in his testimony, but Mr. Swain indicated that he wasn't the target of the shooting. Mr. Thomas did not mean to shoot Mr. Swain. The gun was not pointed at Mr. Swain. He just so happened to get hit as a result of Mr. Thomas stopping the threat that was coming at him. Now, Mr. Thomas told you that he was afraid. He was fearful. He didn't know what Mr. Cooper was going to do because Mr. Cooper had already got physical with him earlier. Mr. Cooper had already got physical with someone else. Mr. Cooper had put his arm around his neck, and we know that it wasn't a tight chokehold, but he had already put his arm around Mr. Thomas's neck and made contact with him.
What is your understanding of what the record shows about Mr. Thomas being present for the Cooper versus Bruce fight?
My recollection is that he was not present.
Mine too.
But he had heard about it because everybody's talking about it, because when someone puts another person in a chokehold sleeper and they nearly, well, I think there was testimony that he went limp. He didn't pass out, but that's what they're going to talk about. And that was a conversation that Mr. Thomas had heard about. But this man is charging at him. So, and not only is he charging at him, he's charging at him from a vehicle. Apparently, Mr. Cooper was getting ready to leave himself. But instead of leaving, he jumps out of a vehicle, and based on somebody's testimony, he sees Bruce and he's jawing off at Bruce, and then he sees Mr. Thomas, and now he's running, hauling ass
Hey, Loki.
towards Mr. Thomas. And as a result, he shot. And Mr. Thomas, during his testimony, indicated that he fired one round, and that one round stopped the threat of Mr. Cooper. Mr. Maddox's testimony is that he kept coming. Mr. Swain's testimony is that he kept coming, and he being Mr. Cooper. And the only time that he stopped, Mr. Carter's testimony is that he kept coming. And the only time that Mr. Cooper stopped is when he was shot. Your Honor, in Gilbert v. State, 94 GA App 217, 1956, the court reversed judgment in a homicide case because it appeared that the defendant had no desire to fight and intended to fight only to the extent that a defense of his own person was necessary. It's clear that Mr. Thomas, at the time of this shooting, or throughout the night at all, had no intention to fight or get into an altercation with Mr. Cooper. At the time of the shooting, Mr. Thomas was at his own vehicle. He was getting ready to leave the premises of the party. Mr. Cooper was the only person with a vendetta. He jumped out of a car to attack Phil. In previous conversations that I've had with the state, it was mentioned that you can't bring a gun to a fist fight. However, there was no fight. The word fight insinuates that there's an exchange of physical blows. There was no exchange, just Mr. Cooper aggressively, verbally, and physically assaulting Phil.
Well, another argument would be there was a single exchange, one bullet, and there wasn't a whole lot Mr. Cooper got to do after that. I don't disagree with you saying there was the approach, but there is some evidence that then Mr. Cooper stopped and either was like this or like this. We've got about 19 different versions about how his hands are, which is, I think, trouble for both sides at this juncture and maybe later on. But I understand what Gilbert stands for. I haven't read Gilbert, but it sounds like maybe there was a situation where someone said, I don't want to fight. And here we have some testimony that Cooper was trying to verbally engage your client, and instead of verbally engaging, your client shot him.
And that's if you believe. It just depends on whose testimony that you believe. Because
right. Well, and you need to help me work through that.
Yeah,
and I guess you're getting there. It's
I
like,
intend to, Your Honor.
Good. Then I'll be quiet.
Okay. Additionally, fists weren't mentioned. However, what Mr. Cooper did say was, I'm going to kill you. Here, there was absolutely no intent, no mutual intent for mutual combat. And the reason why I'm addressing mutual combat is because there are individuals who testify that there was some back and forth. There was no readiness and willingness on the part of Mr. Cooper on the part of Mr. Thomas to engage Mr. Cooper in a physical altercation.
Yeah.
And reluctance or fighting to repel an unprovoked attack is self-defense and is authorized by law and should not be confused with mutual combat. And as Your Honor is also aware, the reasonable person standard is used as a test to determine justification. According to Andrews v. State 267 GA 473, 1997, to establish justification, a defendant must show the circumstances were such as to excite the fears of a reasonable person that his safety was in danger. And that's also citing WETTA, W-E-T-T-A, v. State 271 GA App 128, 1995. In Andrews, the court found that the appellant did not act as a reasonable person. The facts of the case is that the appellant and the victim were at a restaurant to provide transportation to different restaurant employees. The appellant was waiting inside the glass-walled building while the victim was sitting in the car. As they performed their closing duties inside the restaurant, the male employees teased the female employee about the victim, her boyfriend. When the female left, the appellant held the door open for her and called her boyfriend a punk. The victim heard the epithet and responded angrily. When words were exchanged between the appellant and the victim exited his vehicle, and as he placed a key in the car trunk lock, promised to show the appellant who the punk is. At that point, the appellant pulled a handgun from his pants and shot the victim in the back. The appellant ran to where the victim lay on his stomach and shot him 3 more times in the back before fleeing the scene. It was unreasonable for the appellant in that case to shoot someone in the back who had not made any threats. It was unreasonable for the appellant to feel threatened when no threats were made. It was unreasonable for the appellant to stand over the victim and shoot 3 more times. It was unreasonable for that appellant to believe his safety was in danger. However, we don't have the same circumstances in this case. Mr. Thomas was threatened. Other people heard the threats. And it wasn't just a regular, hey, I'm gonna hurt you. It was, I'm going to kill you. I should have killed you. Ideally, when I had the chance. When I had you in that chokehold, that could have been a sleeper, I should have killed you then. So then now you have Mr. Cooper charging, running, full speed, according to Mr. Cooper himself. He was running as fast as his little legs could go. He's running full speed and he's still yelling threats. He's still saying, I'll kill you. And he gets shot 1 time in the front as he's continuously moving towards Mr. Thomas.
Yeah, I don't think she's putting on a amazing case by any means. She's I don't think that was a great example that she gave about what it isn't. You should lean more to citing what it is. But I think the judge said it earlier, which really made sense. Did he not use good judgment? Absolutely. Like, he should have left. He shouldn't have put himself in this position. He never should have done anything. Oh, no reason to shoot the other guy. If somebody comes charging up at me that I've had conflicts with all night, I don't know. It's if in this world that we live in right now, where people step out of their cars and spray bullets at a mall and run over groups of people standing at a bus stop, I think it's iffy, like what's considered reasonable and what's not, because we're not living in the same world we used to live in. Like, what are you supposed to be scared of? Everything? It's kind of hard to narrow that down.
He's not shot in the back. He's not shot in the side. And then Mr. Thomas doesn't stand on top of him and shoot him again.
Look,
although
video.
I think what Mr. Cooper testified to is that he had me dead to rights. After I got shot, I dropped. And he could have stood over me and he could have took me out. That didn't happen. What Mr. Thomas did was he stopped the threat that was coming at him. The physical threat, because you have this man charging at you with what Mr. Thomas saw in the dark was one hand behind his back. Charging at you. You don't know what he has. Mr. Thomas didn't know what he had, but he's running full speed. So there's a physical threat, and then there's the verbal threat that he's making as he's charging at him. It's reasonable for Mr. Thomas to be in fear of Mr. Cooper. It's reasonable to believe that Mr. Cooper, an ex-Marine, a boxer, jiu-jitsu professional, a instructor.
So we don't know what parts of those things that's why I asked you about the Cooper versus Bruce fight. I don't think it's in the record that Mr. Thomas knew that Cooper was a jiu-jitsu instructor or was actually a semi-pro fighter. I know he knows it now, and he may have learned it because he's looked at Discovery, but on the night of May 15th, I think the record is he certainly knows everything that he and Cooper have interacted with. His version of events is punched me in the face, threw my drink. Would have been a whole lot more compelling to say almost choked me out. I'm gonna have to work through how Cooper says, I didn't punch him, but I almost choked him out. But that's routine because that's what happens at Q parties. Whereas your client says, well, it's just one punch. Either way, those things he knew, he experienced them. And then there's the hearsay, but it's in. He heard people say Cooper got a little rough with Bruce. I don't know that the record allows me to conclude that Mr. Thomas knew these things you just rattled off, that this guy is like a human. I guess ninjas were human, but he's a warrior. We did get him to testify. I'm a warrior. I don't know that Mr. Thomas necessarily knew that the night of the 15th.
But what Mr. Thomas did know is that he was a Marine and he'd kill him with his bare hands.
Okay. If I find that statement was made, you're right.
Yes.
Wait, but he was Navy, so Marines can kill with their bare hands, but Navy can't? Is that a thing? Like, serious question. I don't know.
Okay.
So I think Mr. Thomas's case is much different than the case that I just explained as we got to
The guy who got shot on the ground?
Yes.
Oh, yeah.
So that's how we get to the reasonable person standard.
No, I think it is compelling that what happened, I mean, you're going to get there probably, but what happened after the one shot? There was not a second shot or a third. We're standing over him saying, I got you, anything like that. It's rendering aid, not to Mr. Cooper, but to Mr. Swain, interacting with law enforcement, all that. That's something that I need to weave into thinking through what was going through Mr. Thomas's head.
Yes, sure.
Well, Cooper did testify that he held the gun up ready for a couple more seconds. Like, he didn't just immediately drop it. He stayed. I mean, that could be part of his training too. You know, make sure you got him before you fire again.
And in explaining that the facts of Mr. Thomas's case is much different than the facts of
Andrews?
Yes, Andrews.
Wow.
Mr. Thomas didn't make any threats to kill Mr. Cooper. No one testified to that. Also, there was, like I said, I'm going to call it an assault because it probably wasn't wanted, or battery, where Cooper does put his arm around Mr. Thomas's neck. Though he doesn't choke him all the way out, there is that action. And then the charging at Mr. Thomas with his hand behind his back. And I know that there's discrepancy about that. And I know that initially it sounds almost impossible to run with your hand behind your back, which is why I demonstrated how he could have run charging at him with one hand invisible to Mr. Thomas. And then also Mr. Carter testified that he had on these basketball shorts. So when he's running, he's pulling his pants up. So Mr. Thomas, being a distance from Mr. Cooper, only sees this, and it looks like his hand is, he doesn't see him actually pulling his pants up, but his hand's behind his back in that moment, and he's charging at him. So we have that. And there's nothing that even Mr. Cooper does say that a drink was smacked out of his hand, but Mr. Cooper also said that everybody saw that Swain.
What was said so far that was against the rules that would make them demonetize this video? Does anybody remember? She dropped an F-bomb once, but it was way into the video, nowhere near the front, that it would break the rules, but yet they demonetized it already. Love YouTube. I'm just curious if you guys remember something in the beginning. I definitely don't remember anything in the beginning, and I didn't say anything myself.
Saw it, and there were other people during this intervention where the drink was smacked out of his hand, but no one else testified to Mr. Thomas physically touching Mr. Cooper at any point throughout the night. The state presented evidence that Mr. Cooper didn't have a gun. However, Ellis v. State, 168 GA Act 757, 1983 states that the determining factor in self-defense is not whether the victim was using a deadly weapon, but whether the defendant reasonably believed the amount of force he used was necessary to prevent death or great bodily harm to himself. It is not important that Mr. Cooper did not have a gun. What is important is that Phil, as a reasonable person, believed based on the actions of Mr. Cooper, the threats, the jumping out of the car, the charging at him with his hand behind his back, and his determination to get to Phil. And when I say determination, he's running people off. He's blocking people from trying to stop him. He's pushing people out the way. His testimony, and I was going to get to this, but his testimony is that I ran at him, charged at him full speed because I assumed that people were going to try to stop me from getting to Phil. He was determined to get to Phil.
So another thing to think about is he's standing there with a gun in his hand and a guy's charging at him who's also military. So it's not unreasonable to think, hey, this guy just went to his car and got his gun too. Maybe.
So Phil, it's what Phil believed the necessary force was used, what force was necessary to be used in order to stop that threat or to stop and prevent death or great bodily harm against himself. The Georgia Supreme Court in State v. Sutton 297 GA 222 2015 held that evidence was sufficient to support finding that defendant shot his brother-in-law because he reasonably believed such force was necessary to prevent death or great bodily injury to himself or his mother, and thus that the defendant was immune based on justification from prosecution. In that case, in July 2013, Sutton and his sister, Sherry Hardiman, were upset with their sister, Susan Anderson, and her husband, the decedent, for taking money from the mother of the three siblings. This had been going on for some time, and the mother was ill health and suffering from some dementia. On July 26, 2013, Sutton spoke with Susan Anderson and told her that her practice of taking money from their mother had to stop. Later that day, Sutton received 2 threatening voicemails from calls that were made on Susan Anderson's phone. One of the messages was from the deceased. In it, the deceased complained about statements that Sutton had made about him and then screamed into the phone, "You know me, motherfucker. I'll come up there and goddamn tear you a new ass." In the second voicemail, the decedent's stepson, in a profanity-laced call, told the appellee that the next time he saw him, he better goddamn be ready. On July 27, 2023, Sutton and Sherry Hardiman went to their mother's apartment to see how she was doing. Susan Anderson also stopped by her mother's apartment, and a controversy erupted over whether she was going to get money from her mother. Hardiman and Sutton told her she could not get any more money. Susan began screaming and cursing. Sutton called Officer Randy Rigdon and asked him to come to the mother's house. Officer Rigdon did so, and Susan left. The officer listened to the 2 voice messages the appellee received the previous day. Officer testified that it was apparent to him that Sutton was very concerned for his safety. The officer added that the mother told him that he did not want the decedent to come back to her home. Later that day, the officer went by the decedent's home to convey that message. Despite this message, the decedent, his wife, and another gentleman went to Sutton's home at about 8:50 in the morning on July 28th. According to the officer, he and the decedent had been drinking beer, and the group went to the mother's apartment because Susan was hell-bent on getting money from her mother. Sutton was already at the mother's apartment when the group arrived. He was armed with a handgun, which he had placed on the sofa. Although the later arriving group saw Sutton's truck in front of the mother's apartment. Susan Anderson went into the apartment, leaving the door open. She saw the gun on the sofa and said, "We've got one too." Sutton and Susan began arguing, and then the deceased heard the argument. He jumped out of his truck, ran towards the apartment, and others tried to stop him. Rogers tried to stop the decedent from going into the apartment, but he couldn't catch him before he got to the door. When Sutton saw the deceased, he chambered around in his firearm and repeatedly told the decedent not to come any closer, but the decedent nevertheless continued to proceed through the doorway. Sutton then fired his weapon once, and the decedent fell into the shrubs by the entrance of the apartment. He died from a gunshot wound to the abdomen. No weapon was found on the decedent. And in that case, the Supreme Court found that he was justified in killing the alleged victim in that, or the victim in that case. That case is almost analogous to the facts of Mr. Thomas's case. A controversy started by Mr. Cooper erupted. Mr. Cooper verbally threatened Phil earlier at the barbecue, yelling and screaming, and "I'll kill you." Phil informed Mr. Swain, a close friend of his and as Mr. Cooper's, of the verbal and physical assault. Mr. Swain attempted, though unsuccessfully, to defuse the situation, just as the officer was trying to do in the referenced case. Phil testified that he was concerned for his safety.
Absolutely.
Phil was minding his business, getting ready to leave, when Mr. Cooper jumped out of the vehicle he was riding in to leave the incident and ran toward Phil, running at him so aggressively that others who saw him charging at Phil could not stop him. Phil then fired his weapon once, and Mr. Cooper fell to the ground, suffering a gunshot to the abdomen. Unfortunately, the bullet went through Mr. Cooper, ricocheted off of something, and hit Mr. Swain. And just as the Georgia Supreme Court found that Mr. Sutton acted in self-defense, I believe Your Honor has sufficient evidence to make the same finding for Mr. Thomas, as I believe that there's actually more than proof beyond a preponderance of the evidence that was presented over the course of the 2 days. I believe I also gave Your Honor a copy of State v. Green, and that's a 289 GA 802 2011 case where the defendant moved to dismiss the indictment charging him with malice murder, felony murder, aggravated assault, possession of a firearm during the commission of a felony, claiming that he was statutorily immune from prosecution. The facts of the case, and I'm not going to go all the way into the details of the facts of the case, but Green was in fear of death or in fear of a forcible felony that was being committed against him by Walden. And the court found that Walden had placed Mr. Green in reasonable fear of his life and that he had acted in self-defense pursuant to 16-3-21. Your Honor, in the state's questioning, well, back up some. Furthermore, Andrews, the case that I've already cited, states that when a defendant presents evidence that he was justified in using deadly force, the burden is on the state to disprove the defense beyond a reasonable doubt. In the state's questioning of the officers, he called to testify. He attempted to impeach Mr. Thomas and Mr. Carter. However, it was done unsuccessfully. Mr. Thomas and Mr. Carter didn't lie like the state wants you to believe. There were several officers out there. Phil was talking to multiple officers, as you saw from the 3 body cameras, or 4 maybe, that we saw in court. Officer McManus testified, or Investigator McManus testified, that victims and witnesses don't always remember everything the first time they're spoken to. When talking to Phil on the body cam, you can also hear Investigator McManus interrupt him and say, "Hey, I'm not asking you to remember exactly." You also hear Phil say, "I've been talking to everyone." And throughout those different body cameras, you also hear him say, you also hear officers stopping him in mid-sentence. He's trying to act out. He's trying to tell them what's going on. They're like, hold on, wait a minute. I just want you to talk about this, or I just want you to talk about that. So it's not that his statement is untrue. His statement to the police officers are incomplete because he's not allowed to finish telling everything that happened. Or you also see that one, he just shot somebody. So
I think she's tired.
And his friend is also shot, which he didn't intend to shoot. So it's like a disarray. He's scatterbrained. There's still a lot going on. His adrenaline is still pumping. You know, after he's shot a person in self-defense and he ends up hitting his friend too, he gets up and he's immediately rendering aid. They're calling 911. They're in a panic. 911's not answering the phone. So what do? We throw everybody in the car and let's go. 911 won't come to us. Let's go to 911. So he's in a friend, like he's scatterbrained. There's a lot going on. And it's not just Phil who's scatterbrained. There's other people, other witnesses on the scene who are also scatterbrained. So it's not that these statements are contradictory. It's not that these statements are impeachment material. These statements are incomplete. And when Mr. Thomas got on the stand, he had an opportunity to tell his complete story. And that's what he did. He told what happened to him, how it happened to him, and how it made him feel in that moment. In Mr. Carter's first encounter with McManus, there's a lot of him saying yada, yada, yada in his statement. And then the state's trying to impeach him and say, well, did he say kill in the first statement? No, but he said yada, yada, yada. And yada, yada, yada and whoop the whoop are ideally synonymous. And we heard a whoopty whoop too. So the second encounter
is that in the dictionary? Because I didn't know those were synonyms. I thought those meant two totally different things.
I submit to Your Honor that yada, yada, yada was clarified with Mr. Carter saying, I heard the word kill. Whether it was, I'll kill you, I should have killed you, he heard the word kill. And I submit to Your Honor that Mr. Carter is the only one who really has no reason to lie. He's a disinterested party. He's friends with everybody. So he has no interest in the resolution of this case. He indicated that Swain was his best line brother. They're friends. They saw each other last Tuesday. They still hang out, but he still came in and he still testified and indicated that Mr. Cooper jumped out of a car. He ran towards Phil aggressively. He had his hand behind his back as he was pulling his pants up and he was charging at Phil. There was nothing that could be done to stop him. That was his testimony. And Your Honor, even if you don't believe everything that Mr. Thomas said, you can find preponderance of the evidence just from Mr. Cooper and his testimony. His testimony here and the statements that he made prior to today's hearing that he was being asked about while on the stand. So this is what I get from Mr. Cooper. Omega Psi Phi is a non-hazing organization, and hazing is unauthorized actions condoned by the fraternity. But he didn't say hazing doesn't happen. In fact, he said there is a spectrum of hazing. So just because
So he got told to move on. He never actually gave an answer to any of that because it got all argumentative and they went back and forth.
you're over here on the lower end doesn't mean it's not hazing, but it's not this high end of hazing. And hazing, Your Honor, I'd submit to you, is Mr. Cooper calling out all the neos, calling out all the new initiates to come meet him and to come get good with him. According to Mr. Cooper, the neos were still getting used to the environment of Omega. And although he said on the stand that nothing specifically made him that important that the neos needed to come meet him, he also said that if one of the neos were to say, F you, I don't want to talk to you, that would be rude because he's older in the frat. He didn't want to meet the older bros. He wanted to meet the younger ones, the new ones the ones who weren't used to the Omega environment. Phil, an older bruh, pulled Mr. Cooper to the side, a gesture that Cooper indicated was a respectful way to do things in the frat, and told Cooper it wasn't the time or the place for that. Coop took that to mean, and this is his own testimony, that calling the Neos out could escalate to something negative. Cooper testified that he was walking away from Phil. That ends interaction number one. As the evening progressed, people were coming up to an allegedly already calm Cooper, telling him to calm down, telling him to relax. Second interaction is Cooper approaches Phil after what can be considered hearsay statements made to Cooper by other people and says, hey, keep my name out your mouth.
Yeah, I think if she was like, if it was a jury that she was talking to, this would be okay, but it's a bench trial and the judge has heard all this and she's repeated herself 5 times and he's going to get annoyed with the fact that she keeps saying the same thing over and over and over again. Like, I know, I heard it the first time and I heard the 10 times you said it after that.
I don't see how anyone can say walking up to someone and saying that is done in a friendly manner. Like Cooper tried to say it was. Keep my name out of your mouth is aggressive in any context.
Will Smith actually said oucha. There was no out of your, it was not enunciated. And it was said a lot more aggressive than that.
Phil walked away from Cooper. And as you can tell from his testimony, that pissed him off. You gonna walk away from me when I'm talking to you? People, after that second encounter, people are still coming to an already calmed down Cooper, telling him to calm down and relax still. It's almost impossible to believe that this show dog, this live 5, this person who doesn't just sit in the corner drinking his drink, this warrior is as calm as he tries to make it seem. Interaction number 3. The interaction number 3 is an intervention with Cooper and Phil and other bros, including Swain, according to Mr. Cooper. And although Swain testified that he wasn't there for that part, Cooper alleges that there was a back and forth between him and Mr. Phil, and Phil throws a drink on him. There's no testimony from anyone that Phil threw a drink on Mr. Cooper other than what Mr. Cooper says. There's no testimony that Mr. Cooper had to clean himself up, although there's testimony that Mr. Thomas had to clean himself up after his drink was punched out of his hand. During that interaction, Cooper testifies that he did a jujitsu move on Phil Thomas, a move that is intended to incapacitate and or subdue, and on direct indicated that the move could put someone into a permanent sleep, depending on the person. He testifies that he then leaves Phil's presence after whispering in his ear or something, but then goes back and does this same jujitsu move on someone else. Except that one was a little more serious because he caused someone to come to get weak in the knees or to go limp. I won't.
So just random thought. I'm sure you guys have seen the news with the Jordan Neely in the subway in New York with the guy that put him in the chokehold, which was basically the same move that they're describing here. The judge hasn't rendered a decision in this yet. And it makes me wonder if that whole situation would have any influence on how he thinks about this. Just a random thought.
Add words, but that was my interpretation. Incident or encounter 4. After Cooper has now changed clothes in the middle of the living room, he goes outside and he sees Phil again. Phil is outside minding his business. Nobody's thinking about Cooper. You are not the center of attention, sir. Everybody has moved on. But Cooper sees Phil and he gets riled up again. He's with the rah-rah. He's on it.
He's a live
Then there's some
fire.
alleged back and forth between Mr. Cooper and Phil. And his fraternity brothers are telling him, bruh, just leave. Just go. You already said you had something to do. You're dressed. You go. Leave. Cooper said, I ain't going nowhere. I'm not leaving. Why I gotta go? I just want to talk to the man. I want to talk to Phil because it's not safe to have an issue with someone in Atlanta that he doesn't know. However, on cross, when Attorney Foster was asking him, well, it wouldn't be safe for Phil to have issues with somebody that he doesn't know in Atlanta. It was different for Phil. Phil can have issues with somebody he doesn't know, but Mr. Cooper can't.
This whole hearing's been very informal.
After 4 negative encounters,
Which makes it interesting.
Mr. Thomas, then we get to the incident that leads up to the shooting. Cooper jumps out of a car and hauls ass, his words, not mine, at Phil, full speed, as fast as his little legs could go.
Hey, Pat.
He's running full speed because he assumed that if he walked up casually, he would be stopped by other people and unable to get to Phil. Those are his words. He didn't want to be stopped. Mr. Cooper indicated that Phil allegedly had one hand behind his back. But although Cooper also testified that if someone has a hand behind their back, then they have a projectile, not a knife. However, Cooper kept running at Phil. He kept charging at Phil. He never stopped. Cooper, the state's witness and alleged victim, said all of his scuffles or fights were on defense and not offense. That's what Cooper said about his interactions. The moment Mr. Thomas fired his one shot, he was on defense. Mr. Cooper also said, no one shows up to the party wanting to do stuff, but if I have to defend myself, I will. I know there was some conversation with the state and Mr. Thomas on direct. Oh, so you just bring a gun to a cookout? No, I bring my gun everywhere I go. 99.9% of the time, my gun is with me and it's in my car. Mr. Thomas didn't come to shoot anybody. But in the words of Mr. Cooper, if I have to defend myself, I will.
Okay, another random thought. He's an athletic director on a college campus, and I'm pretty sure you can't take guns on college campuses. So he wouldn't be able to take his gun with him 99% of the time. Yes, this is the immunity hearing to see if he is immune from self-defense.
On May 15th, 2021, Mr. Thomas was put in a situation where he had to choose himself. And in that situation, in that moment, he did choose himself because that was the only thing that he could do. And because that was the only thing that he could do, he should be justified. His actions should be considered justified, and he should be immune from prosecution.
You done? That's it? That was
Thank you,
the
Ms.
end?
Hawkins.
Oh,
There's one little yellow piece of paper up there. I don't know if that's yours or if that was already up there.
That's my sticky note that says judge's copy of
All right.
cases.
Thanks. Mr. Costello?
Judge, may I approach with a copy of a case I intend to cite?
some people
Sure.
do.
I have a copy for the defense.
There's certain people, just like some people keep a pocket knife on him all the time, which it's a little more useful.
Thank you, sir.
I think it depends on where you live.
It's a cab case, huh?
I had to bring one. I had to.
So I saw we had a Judge Baxter case from Ms. Hawkins.
You did.
Thank you, Judge. Before I begin, I'm going to give you a little bit of a roadmap of how I'm going to take this final argument. I'd like to classify the type of force that was used by Mr. Thomas in this case. We're going to look at the statute. We'll apply the facts that are in evidence to that statute, talk a little bit about some case law, and then I'll end with some policy considerations for the court. But first, I would like to address a few of the things that the defense brought up in their case, or the beginning portion of their final argument. The Gilbert and Andrews cases are references to jury trials and not immunity hearings. In the Sutton case, I think that the facts of that case are quite distinguishable from what happened in our case, in that there was 3 prior incidents of threats before the actual act that was ultimately deemed to be justifiable. And it was also where the defendant was coming to a home. And that's not the case here, as Mr. Thomas was at Christopher Swain's home, and Mr. Cooper was staying with Mr. Swain.
But in Sutton, as I understood it, and I understand it only through Ms. Hawkins's narration of it, in Sutton, the person who was shot was coming not to Mr. Sutton's home. Mr. Sutton was there with his mother-in-law.
And I do think it was the mother-in-law, but this is Mr. Cooper not coming to necessarily a place where Mr. Thomas is there to check up on the concerns of someone, because that was a big part of the facts of that case.
Okay, well, I'll read Sutton and work through it.
And I believe that the defense talked about, the defendant's statements made to officers and how they interrupted him, and maybe you're not getting a full, clear picture of some of the statements made by Mr. Thomas at the hospital because he was scatterbrained. And I do think he was scatterbrained because Mr. Thomas was talking about some things that were outside of necessarily the realm of the shooting. And I think the officers were trying to boil down what actually happened in the shooting.
Kept wanting to tell them about the chapters and the different chapters. That's not what they were interested in.
It did not appear so, Judge. And last, there's this line about Cooper being a Marine who could kill someone with his bare hands. And, the defense can address this with their reserved time, but I don't believe that's in evidence. That may be related to an interview that I had with Mr. Cooper that's in discovery, but I don't think that that's really part of the facts of this case and what led up to the ultimate incident.
Well, and I'll sift through that. I don't want folks to spend too much time on that particular line. I think there is in evidence some witnesses saying, I heard Cooper say something with the word kill in it as Cooper is approaching Thomas for that final encounter. I think there are disputes about that, but there are people, to include Mr. Thomas, who have said, this is what I heard Cooper say as he's heading towards me. I'm standing at my car and he's coming towards me. So whether the Marine thing is swirling around, I'm going to factor that in the same way. Did anyone know that this guy was a jiu-jitsu white belt or anything like that? I think a lot of that was brought out to help paint a particular image of Mr. Cooper, which is not irrelevant, but it's not germane to the calculus of what would the reasonable person do in Mr. Thomas's situation if the reasonable person didn't know that particular fact.
Yes, Judge. And, so in classifying the type of force that is used in this case, Mr. Thomas did use deadly force, right? A firearm is a deadly weapon when it's used in the manner in which it's intended to do. So in this case, it was pointed in a direction of a person. It was fired. It was discharged. A round went out. If he was pistol whipping somebody, it would be an object that's offensive, and it would have been indicted totally differently.
I haven't heard the defense say they need to meet a lesser burden, that they're acknowledging that because it was a firearm and it was fired, it wasn't used as a a projectile, as in someone threw the gun at Mr. Cooper, but that Mr. Thomas shot it, that they need to prove by preponderance that it was reasonable to use deadly force.
And under 16.321, Judge, defendant can only use deadly force if he reasonably believes such force is necessary to prevent death, great bodily harm, or a forcible felony. So we're not talking about a forcible felony here, even if Your Honor were to take into account that.
Why aren't we? Because the question I had for you is, if the only thing I credit is Mr. Cooper's testimony, which ought to be most favorable to him, it's his version of offense. According to him, he committed an aggravated assault on Mr. Thomas earlier that night. He's saying it was in defense because Mr. Thomas tried to tackle me. Having met the two of them seems ill-advised because Mr. Cooper's going to get the better of him. And he quickly did this jujitsu hold. My legs were here and pressure, but then I let him go once I had established that, hey, I'm in charge and this isn't going to end well for you. So Mr. Cooper had done that. And now he's zooming towards, by almost everyone's account, he's his own account. Again, I am, as fast as my little legs can take me, I'm running towards Mr. Thomas. And my hands are visible, but it's my hands that I'm gonna get you with. And I've already done it once. I mean, it was legs too, it was all these jujitsu body parts, but why is it not forcible felony that Mr. Thomas is reasonably concerned, this guy's gonna choke me out again? Strangulation, ag assault is a forcible felony. It's a pretty low hurdle because they've added forcible felony. And a lot of people think, oh, armed robbery is a forcible felony. It is, but it is the aggravated assault that's the part of the robbery that gets you there. And so walk me back from, if all I credit is Mr. Cooper's testimony, it's reasonable to believe that he was going to commit an aggravated assault, a forcible felony on Mr. Thomas. And so Mr. Thomas was justified in saying, I'm not going to be choked out again. That wasn't so fun. So here you go.
Yes, Judge. So I think Cooper's testimony about the jujitsu hold, the choke hold, is it's important that he said it's to subdue or incapacitate, and also that Mr. Thomas was acting as an aggressor towards him first.
No doubt about it. And so I'm not wondering why didn't you guys indict DA's office from Fulton, indict Cooper for aggravated assault. But that incident had just happened. And so if we're thinking along the lines of Sutton, where what Ms. Hawkins shared is that the sister-in-law of Sutton said, oh, we got one of those too, when she saw Sutton's gun. And then Sutton sees someone running towards him from a car, like, oh, he's got one too, so I'm gonna shoot him. It was reasonable for, and I understand there's more to Sutton, and I don't want to run down that rabbit hole, but even if what
He said
Cooper
rabbit hole.
did was in response to being tackled-ish by a guy 10, 15 years older who is not a professional boxer, wrestler, jujitsu, etc. Now it's Cooper who is running after Thomas, who has just recently experienced the hold of death or whatever it's called.
And after that incident ends, there is, if Your Honor recalls, there is roughly a 2-hour gap where there is a de-escalation period. There are other members of the fraternity, other friends from the party. They're separating Cooper. They're separating Thomas. Mr. Swain testified that he was with Mr. Thomas for 2 hours.
But Mr. Thomas also knows now that Cooper can beat his ass. So he has a reason to be scared.
And there's nothing to discredit that testimony. And actually, the way that the timelines have been brought into evidence is actually, it kind of lines up, because we have this encounter with Phil and Cooper where the jujitsu move is brought in at 9 o'clock, and then our shooting doesn't occur until well after 11. And during that time, where Swain is de-escalating this situation with Mr. Thomas, who's on the phone, who's calling people, he's making comments about shooting Coop. There's testimony and evidence he's looking for a gun.
Okay, you're going to need to highlight that for me. And you're talking about de-escalation. Maybe Swain is trying to de-escalate the Cooper Thomas situation. But in that 2-hour window, we also have the Bruce with his tiny fists and Coop's at it again, choking someone out. And Mr. Thomas doesn't know all the details of how that played out, but I think the record shows that he's aware that Coop, maybe not a man of peace, managed to get into a different fight during those 2 hours. So it may be that Swain is trying to de-escalate Cooper versus Thomas. The record doesn't seem to suggest that Coop himself is spinning down, but rather either maintaining the who do I fight next or spinning up.
I bet this judge is great at telling stories, like just sitting around the table, reminiscing on the past. He's comical.
While he may not be spinning down because of the outcome of what happens in the home, he does make the decision to leave with family and friends when they decide to go to this other party, and he goes into the living room to change. And it's while he's changing in the living room, well, that may not be the most preferred method to get changed for the people in this room. It's where he makes eye contact with Bruce, and when he starts walking towards Bruce, Bruce is the one that actually engages, based on Mr. Cooper's testimony, that he raises his fists up. And as Mr. Cooper testified later, he was on the defensive with this jiu-jitsu move. And again, these are moves from Mr. Cooper's testimony meant to subdue and incapacitate. No other individuals, to my knowledge in this case, needed to be treated at the hospital other than the ones that were shot. So I do think that Mr. Cooper, being the trained fighter that he is in a martial art, used those moves to subdue potential threats and then disengaged before he could inflict more serious harm if he wanted to, and clearly appeared to have an upper hand in doing so.
But that's the thing.
So,
He could have easily.
The evidence that I have about Mr. Thomas trying to get his gun is through Swain's testimony.
Yes, Judge.
Okay.
And I think that in that 2-hour time.
And remember, this prosecutor got brought in from another county. This shouldn't even be his case. He got brought in from DeKalb County because there was conflict of interest with Fulton County prosecutors.
Frame where phone calls are being made. There's an allegation that he was intending to shoot someone. He's looking for a gun. This looks like there's some premeditation forming. And we're talking about the element of intent for crimes that are indicted. And that's an element that needs to be proven by the state beyond a reasonable doubt at a jury trial. And that's quite a hurdle for the state to make. While it can be inferred by proven circumstances and conduct, it's still something that we need to prove. I do know that the defense also brought up the, while I'm speaking about intent, about that the fact that Christopher Swain was not intentionally shot, that it's a ricochet, it's a through and through. There's some evidence about that. Well, here, Judge, is your classic law school textbook hypothetical of a transferred intent case,
Exactly.
which again is something that needs to be proven by the state beyond a reasonable doubt at a jury trial.
No, I understand. There's also transfer justification. So if I find it's justified, I think everything goes away. But I don't, if this were clearly not self-defense, if Mr. Thomas from 100 meters away had said, "There you are, Cooper, I'm so mad at what you did," and Cooper's saying, don't shoot, and he shoots him, hits Cooper, and it hits Swain. I get it. I had never meant to hit my neophyte. Well, you did when you shot Cooper. You hit Swain as well.
So going back to the statute, Judge, so I don't think that Mr. Thomas was preventing a forcible felony at the time that Cooper is running at him. And I don't think that Mr. Thomas was trying to prevent himself from receiving death or great bodily harm. And that's from the evidence that we have from a defense witness, right? Mr. Carter is testifying not only on his direct and cross-examination, but also in the body camera footage tendered in through the investigator. Cooper's running, his hands are out. He's making motions that the hands are up, the hands are visible, and that there is not a weapon in sight.
And maybe this is what's in Mullins. Is it? That's
Really?
all right. Okay, that's a funny sound. That's the way of letting everyone know we're approaching 2:00. Thank you for doing that. If Mr. Cooper had been approaching with a machete, it's a totally different calculus. It's his hands, but hands can be deadly weapons. We know that. That's more complicated, et cetera. But is there case law you'd want me to look at that supports a trial court judge ruling denying a immunity motion because it wasn't reasonable to think that your opponent really could hurt you all that much? And I'm thinking, I mean, this is an exaggeration, but the guy who ends up shooting is 6'9", 300 pounds, and the guy who shoots, who's coming at him with his fists up, is 5'2" and 80 pounds.
And I don't think I have any particular case law on point for that specific issue. Mullins goes into kind of more of a verbal threat in accordance with some additional actions that occur throughout the course of an evening at a party. But I think that when we look at the test for preventing,
They're saying that he restrained himself, so it's okay.
great bodily harm or death, we need to look at whether that threat is imminent. And I think because we have a significant distance that was testified about throughout this hearing, whether it was 200 feet when Cooper started running, 50 meters, 100 feet, it was all kind of a significant distance of probably 100 feet or more where Cooper starts running. Now, Mr. Thomas picks this up, as I think we get from Mr. Swain's testimony, where his eyes were moving towards something. And I think that's where Mr. Thomas could have made choices. And I know that we don't have a legal duty to retreat, but he could have made a choice throughout those 100 or so feet to get in a car and leave, to get other people at the party to assist him. And I think that the timing factor of this is it's not imminent. He had more than 100 feet to react to what Cooper was doing.
That's not a lot of
could have
time.
extricated himself from that situation. So the timing of this, it means it's not imminent.
You'd have to get his car door open, get around it, and get in the car.
Some of the evidence that was brought in, Judge. I want to first start out with some of the state's witnesses. And I think that Mr. Maddox brings up a lot of good points from his testimony. I do understand that there was he may have had some confusion while he was testifying about the moving of the car. And Your Honor touched on that. It might not move the needle a whole lot for you. But I think what's important about Mr. Maddox is he gives you a distance. He does it in not only his direct testimony, but in the two statements he made on the body cam, that Cooper's hands were up, they were visible, there was no weapon. Again, Christopher Swain's testimony, we're looking at a 2-hour window where he's de-escalating Mr. Thomas from whatever occurred between him and Cooper. And that during that 2-hour period, there's some potential intent forming. There's a searching for a gun that's for some reason in the back of the car and not normally in the center console under the seat or in the glove box, where Mr. Thomas usually puts his gun when he's in the car. And then he's arming himself in the process of that instead of leaving the firearm inside of the car where it would normally stay. Also, Judge, in cases of self-defense, typically we're looking at something that's like instantaneously happening. And I think that this cooling off period between whatever happened in the house with the jujitsu hold and the actual shooting itself, that 2-hour window, that takes any kind of instantaneous out of it. And again, this goes to the imminent threat as well. And then we have Mr. Cooper, and the defense has harped on, this was one shot, the threat was stopped. But Mr. Cooper did also testify, and I'm not going to rehash and belabor his entire testimony. I think what's important in his direct examination was that the gun, after it was discharged, was still pointed at him, and Mr. Thomas's finger was curled and still on the trigger. As far as the defense witnesses go, I've already kind of addressed Mr. Carter, and I do think that Mr. Carter provides a pretty middle of the road, unbiased account, considering he is friends with a lot of people. There's really he doesn't have necessarily a stake in this game as maybe some of the other witnesses do. But Mr. Carter's statement did change between the 15-minute time frame where he gave the initial statement to Investigator McManus to the second statement. And during that 15 minutes, Investigator McManus does become involved in the interview with Officer Vickers, Officer Barnett, and the defendant. So it's possible that, hearing the defendant interject the word kill in the statement he's giving is maybe potentially influencing that second statement that Mr. Carter made. In looking at Mr. Thomas's statements on direct, I would say, Judge, that it is self-serving testimony, and as a trial court, you are authorized to reject that. That's from Ellison v. State, 313 Georgia 107. That's a 2022 case, and I think that we know.
Give me the site again, please.
Yes, sir. 313 Georgia 107.
Okay.
And I think that we know that it's self-serving testimony because there's a lot of differences and inconsistencies throughout the multiple statements made by the defendant prior to the hearing this week and what he testified to on direct. If I recall correctly, on direct, he had mentioned that Cooper was lunging towards him with one hand up and one hand behind his back. That hand was Cooper's left hand. But there's no mention of a lunge in any of the prior statements after the incident at Grady Hospital to officers. The defendant also testified that when he fired the shot, he was just a few feet away from Cooper. However, I think when you juxtapose that to the statements he made to law enforcement, there's several feet that he's talking about. He's talking about 6 to 8 feet, which is more consistent with what the other witnesses have said. And that's for Cooper, Swain, Maddox, Carter. They're all saying that there is somewhere between 6, 7, 8, a car length, a significant distance when the round is discharged. Also, the position is inconsistent in the defendant's statements. I believe on direct, he testified that Mr. Swain was in front of him, but in the prior statements to law enforcement officers, he's saying that Swain was off to his 9 o'clock or to his left, which is that's inconsistent with some of what the other witnesses were saying, including Mr. Swain himself, who said that he was conversing with Mr. Thomas, turned around and tried to stop Cooper from coming at him. But we know that the evidence shows Cooper was coming directly at him. So Swain also must have been directly in front of the defendant prior to the shot being fired. And if you'll indulge me on the Mullins case in just a second, Mullins is about, it's about a case that the crux of the opinion is about Chandler evidence. And I know that we're not talking about Chandler, so just bear with me. I'll bring it all home at some point. But what's important in the analysis in Mullins is the focus that's made on the immunity hearing. I think it gives good guidance for us in this particular situation because the facts are pretty similar. And the site for Mullins, for the record, is 299 Georgia 681 2016 Mullins versus State. On the night in question, Mullins and his friend attend a house party in DeKalb County. Some of the party goers spill out from the house into the street. The victim and his friends are socializing. They're drinking at a house a few doors down. And the victim's friends testified that the victim was drunk and he was dancing on cars with his shirt off during this party. At some point, there's some gunshots that go off. People start leaving. And Mullins gets into his car. In an attempt to leave the area, he almost hits the victim. So this leads to an exchange of words between the two. It's an angry exchange of words. And according to witnesses, Mullins brandishes a gun at the victim, but this first encounter between them, it ends and the victim walks away. Several minutes later, a second encounter occurs between Mullins and the victim. Mullins told a witness, "I'm going to get him," drove near the victim, stepped out of the car and shot and killed him. Several witnesses testified that the victim was unarmed when he was shot. Mullins provided inconsistent statements to police. In one recorded statement, he admitted he never saw a gun, but he did say that during that first encounter, the victim said he was going to get his tool, a euphemism for a gun. At trial, Mullins also testified that he shot the victim based on the fact that the victim mentioned the tool, but also because he had snatched it at his car door and moved his hands quickly. Mullins eventually is convicted at a jury trial, and on appeal, they're looking at Chandler evidence, but at the immunity hearing, where immunity was denied and this did go to a jury trial, none of the defense witnesses stated that the victim assaulted or attacked Mullins at the time of the shooting. At the time of the shooting in this case, after a 2-hour cooling off period, there's not necessarily an attack. There's a running at somebody from 100 feet away, but not an attack. There's no blows landed. There's no jujitsu holds before the shooting. None of the witnesses said that they heard what was said between the appellant and the victim during, this second encounter that ends in a shooting. I think there's conflicting testimony about whether or not the word kill was said in our case. Cooper says, "I didn't say it." Mr. Thomas said, "He said, I'm going to kill you." Mr. Carter said at one point, no, the word kill was not used. And another point, he said the word kill was used. Mr. Maddox said the word kill was never used. And Mr. Swain said the word kill was never used. That's going to be an issue that the jury should have to reconcile.
He's trying to pull in a case that the guy was obviously the aggressor. The shooter was the aggressor. And that doesn't really line up with this because at the point in time that the shooting happened, the shooter was not the aggressor. He was standing there having a conversation when someone approached him. So that's hard for me to process those two.
The court pretty much analyzes and concludes that Mullins' rationale in his shooting, it didn't establish a prima facie case for a justification jury charge, and it cited another case that I'll give you the citation for in a minute, that verbal threats and fisticuffs do not justify the use of deadly force. Which the citation on that is 273 Georgia 844 from 2001. The Georgia Supreme Court also said verbal threats and fisticuffs don't justify the use of deadly force. That's a case where the victim verbally threatened, took a swing at the defendant, and the court held that the defendant could not establish a prima facie case of justification because when he stabbed the unarmed victim, as Mr. Cooper was unarmed in this case, he was not honestly defending himself.
But I think that's also a case where he knew that the other person was not armed. And in this case, they're not sure that he wasn't sure if he was armed or not. He came charging at him with his arm behind his back. Hey, Cool Frog. Welcome, welcome.
In looking at this case, Judge, I think it's also, it's very important to recognize that Mr. Cooper didn't have a weapon at the time of the shooting, nor did he have a weapon at any point during the 4 to 5 hours that he is at this party. When you look at the defendant's version of the events that day, I think it's inconsistent with a lot of the other witnesses that have been called to testify at this hearing. Again, I think that testimony provided on direct from the defendant is self-serving. And I think that the evidence that's in this record is insufficient to carry the defense's burden of proving that by a preponderance of the evidence, Mr. Thomas's actions were justified on May 15th, 2021. And, just kind of ending with this policy question, Judge, I think, and I'm not breaking any news here that shootings are on the uptick in Atlanta over the past 3 years. Former Mayor Keisha Lance Bottoms said that the reason for a lot of these shootings is the inability to properly use conflict resolution skills. And that's exactly what happened in this case. There was an inability to use conflict resolution skills. And you can't use a gun to resolve conflicts such as this. You can't bring a gun to a fist fight. You shouldn't bring a gun to an argument. And you can't settle a verbal dispute or somebody running at you where you don't know what they're going to do with any kind of gunfire. You cannot settle a tussle with deadly force. So in conclusion, Judge.
And that's another thing. He didn't bring the gun to it. He was standing there, had the gun in his hand because he was transferring it from the back of his truck to the front of his truck when someone came charging at him, and he was fearful. So it's not like he was aggressive and said, "Oh, I'm going to go get my gun. I'll be right back."
I would ask Your Honor to deny the immunity motion, as I think the evidence in the record is insufficient for the defendant to carry its preponderance burden, and the defendant should not be immune from prosecution. I think that there's enough inconsistencies in this case to go to a jury. And in citing Anderson v. State, 245, Georgia, 619, it's a case from 1980, the fear in a reasonable man justifying deadly force is a jury question. Thank you for your time this week, Judge.
Thank you, Mr. Costello, and Ms.
not a
Jackson
jury
and
question.
your office for standing in for the Fulton DA's office. So, Ms. Hawkins, you did reserve, I'm gonna give you just a couple minutes because you were very thorough, and what you argued prompted my questions that I've already posed to Mr. Costello. So
I think the defense really missed it by not focusing in on the fact that with his jujitsu skills, he does have the ability to be deadly without having a weapon. And the fact that he had him in the headlock, all he had to do was squeeze just a little bit harder. He could have killed him. So that gives Phil an extra reason to be fearful when he comes charging at him later. What if he does the same thing and just doesn't let go this time? And they haven't really touched on that at all. They haven't touched on anything about the jujitsu and all of that.
Yes, Your Honor.
when you're ready.
Yes. There was nothing inconsistent about what happened in the moment that the shot took place. And Your Honor, we talk about policy and using conflict resolution skills. Cooper didn't use any conflict resolution skills.
Both, I think it's very clear that both gentlemen would benefit from some anger management, conflict resolution, et cetera.
Right.
And, the state talks about policy. Georgia allows people to carry. And Mr. Mr. Thomas was carrying legally. He's allowed to do that. And he's also allowed to defend himself because Georgia allows that too. I think the state misrepresented a lot of the facts that they used in their argument. However, I'm not going to go through that because Your Honor took very good notes. And I know you can sift through what was said and what wasn't said. But to touch on the premeditation, which also touches on the Mullins v. State case that the state introduced. If this was premeditation on the part of Mr. Thomas would have went to Cooper. Cooper came to Phil. The Mullins case talks about how.
I hear you on that. I didn't hear Mr. Costello saying this was all a plan and Mr. Thomas knew Cooper would come to him. What I heard him saying is, if this were purely self-defense, then you're just almost like, oh my gosh, here he comes. But there is evidence, slight evidence, but there's some in the record that Mr. Thomas had this animus, this anger, this something about Cooper, and you've explained why he might. But Mr. Swain says, I'm trying to get Thomas out of here because like, where's my gun? I need my gun, this Cooper guy. And then there's whatever mystery's going on with Mr. Royals. It's not in the record other than that there's testimony about he called, I think Mr. Thomas even talked about calling a person he knew who was a tri-mu, who was Mr. Royals. And so there's been some oblique references to that. And so I think it's appropriate for me to consider, based on what little is in the record, that there's something out there suggesting that Mr. Thomas was either scared enough, maybe more your argument, angry enough, that's the premeditation intent. Like, I'm gonna get my gun because if this fool comes up in my face, I'm gonna show him something. And so maybe that is it's not quite a preponderance that it's immunity. There's still a compelling self-defense argument here. I think that Mr. Costello had to acknowledge that in his closing argument. But is that evidence of premeditation? I'm thinking about getting this guy enough to take us out of it was so pure as the driven snow self-defense when Cooper was coming towards him. And I have to weigh that with there being some testimony that Cooper says, hey man, I don't have a gun. And how does all that play out? So I just don't want you to spend a lot of time saying there's no proof of premeditation. I didn't hear the argument being this was an intentional killing, it's murder. The pushback was it wasn't so much this last minute reaction of here comes death and I'm going to protect myself from it. That for a while, Mr. Thomas might have been thinking, I want my gun because I don't like this guy. That's all.
And again, that's who your honor decides to believe. Because I know this is not a jury trial, but you are the fact finder.
I am.
You're not at a jury trial yet, or if we ever make it there, but you get to determine what amount of credibility or the weight of credibility that you give to the other testimony. But I will say that the state indicated that on several occasions, Mr. Thomas could have made a different choice. Everyone could have made a different choice. Cooper could have made a choice not to call the Neos out. Cooper could have made a choice not to put Phil in the jiu-jitsu wrestling position. Cooper could have made the choice not to run charging at Phil. And we wouldn't be here had he had made better choices. And for those choices, there are consequences. And as a result of the consequences, Mr. Thomas should still be immune from prosecution because he had to make a choice in that moment as well. And that was to defend himself.
Got it. Thank you, ma'am. And thank all four of you attorneys for your work on this.
And that is it, my friends. We still do not have a result. It is still under advisement. I think he might be waiting for the May 23rd hearing to give his ruling in the matter. On me. Got stuff in my shirt. I personally think that given the fact that this is in Fulton County has such a huge backlog of cases. They've got half of their office tied up on the YSL case. They've got so much going on that this is not the type of thing that they should be focusing their attention on, in my opinion. I mean, you have a lot of dangerous people on the streets in Atlanta. Focus on that. Like, this guy is not, he didn't do right. He screwed up a lot. I think we all agree on that. They both did. But they probably learned their lesson just from what they lost in life. He lost his job and everything else, and friendships lost, the drama they've had to go through, the court cases, everything else. They've lost a lot. He's an intelligent guy. He's got his PhD. He was doing well for himself. He probably learned his lesson just from that alone, and jail isn't going to really reform him anymore. So focus on more heinous crimes and let this go to civil court where Cooper can sue Thomas and get whatever money to pay for his medical bills and his pain and suffering and all of that good stuff. Thank you so much for stopping by. Next time, maybe it'll be a little more interesting. It's a weird one. Yeah, I don't know. There's so many other things that they could be dealing with that it just doesn't feel like this is the thing to be going after right now. Yeah, they're not doing much right now. Seems like every time I'm on, that's when they're passed out. But hey, did you all watch the verdict in the Letitia Stout? I still can't say her last name. Stout case last night. I'm sure most of you did, but if you didn't, you really need to go watch just the verdict. Just fast forward to the end. Don't watch the impact statements because those are rough. But listen to the judge's comments. It was an excellent statement. He said a lot of really impactful things, and it was really impressive and good to listen to. So I have to go get some new glasses because I can't see crap. And yeah, I feel like I need therapy after watching that. It was rough. It was so rough. And I was trying to get home from taking my kid to the dentist and listening to it in the car, like, oh my God, I had to turn it off till I got home. Then I watched it at home and I was crying on my computer. It was hard, but what the judge said, just it made so much. Like, he needs to be higher in the world and able to make a difference. What he said about the impact on people with real mental health problems and things like that was so spot on. Like, chastising her for making, like, hurting people who have true mental health issues that are actually insane by the legal definition, compared to her who's trying to act like it just to get out of it because, nothing else worked. The chance that they won't be believed and won't get the help they need because she's selfish. It's rough. She is just an absolutely despicable human being. Which, compare that to this case we're watching right now, and it's night and day. Like, this guy is not a saint by any means, but I don't think he is like, went out there like, I'm going to shoot somebody. He just made a bad decision in the heat of the moment and move on. But we learned a lot about frat bras. I always thought you spelled bra, B-R-A, but apparently you spelled it B-R-O. B-R-A-H. I don't know. No, he's not a monster. He's not. And we have enough monsters in the world. Like, go chase them down. Go find them. And yeah. All right, everyone. You have a wonderful afternoon. I got a few things in the works for you that I will try and get out as soon as I can. Bruh. But it's bra. It's bra. You got to have that A at the end. And I don't know where the A comes from. That is not how I was taught English. Apparently, I went to the wrong school. And the yada, yada, yada. That doesn't mean what I thought it meant. I don't know. I'm lost. Need someone to teach me. I have to find a 5-year-old somewhere. All right. See y'all later. Have a great one. Adios.